This application was made and before the results were fully tallied and announced or declared, the applicant sought a mandatory recount to be conducted by the returning officer under Section 73 of the Parliamentary Elections Act. Which imposes a mandatory duty on the first respondent to conduct a recount where either the top runner-up candidates have obtained equal votes, or where the margin separating the winning candidate and the immediate runner-up is less than 50 votes.
Is
less than 50 votes. And the request is so made in writing. Your Honor, it is proposed by the applicant the applicant made an application for recount as indicated under paragraphs number 4, 5, 6, and 7 of the affidavit in support, and also confirmed by Annexure B to the affidavit in support. Your Honor, this mandatory recount was declined by the first respondent reasoning that she had already declared the results as indicated in Annexure C to the affidavit in support. Your Honor, all respondents have filed affidavits in reply to this. Have filed affidavits to this application. The first and second respondent's affidavit, Your Honor, is deposed by Mr. Kayondo. The first and second respondent's affidavit is deposed by Mr. Kayondo Abubeka, a senior legal officer with the second respondent. Your Honor, in particular, court will note that the first and second respondent is not denied. That the applicant made
kyengamba kati ababaka balinga abadduka kiri bakitadde ekyo bwa pulezidenti lwakuba bawangudde buno obufo kyobola bagamba obufo obwo ne Besigye yabwogerako obufoofofo balindeko okujaganya nze sigamba mu kibi naye balindeko bali mu kutta nti
obadde oyagala kale bakole batya so ani gwala byajaganya
yeye bangi bobeera ku social media omanyi gwobeera busy
andi babadde balina okwebaza abantu ababawadde akalulu kyabadde kibi
ate nze wano omuntu ali mu comment section njagala serembe obagambe nze nkunoonya nenkugwako nenkukubakuba ebinnyo nze simanyiirwa muntu wa comment section nze seremba wunye mu mugambe
ngabo wakubaani
sebana waliwo nekivuga kisebana nakinoonya nenkifuna nze simanyiirwa abantu ba mu comment section wonnemerera n'okuloga nkuloga
balaba byoyogera tebikwataganye kuba ababaka ba palamenti buli muntu eyalonderewe yalonde uliriza katono mbaka palamenti buli muntu eyalonderewe yalondedde n'omukulembeze we ge yadakkirizamu yasobola okuwangula Amanya abavuzi bakubba mwawuguka kati naawe byoyogera bya kiwugulavu
waliwo wanaakugambye gwe Seremba Jimmy kyogamba ba MP kyebakola kituufu ekyokujaganya
andi mubuuzizaani ani mweyala byajaganya mbaka palamenti yenna musajja we muting musaba busabi
bagamba byebituufu okitegeera MP tebalina makulu nga president aliwo kiringa kujjanjaba mutwe kiringa kujjanjaba mikono ate nga ngenda kumulwadde
mbadde sebo nkwagala Malemadi we muting ko nyini nkwagala nnyo sebo webale nnyo webalire ddala sebo njagala nkubuuza ebibuuzo bino obinziremu Malemadi ayinzo ate lwaki odduse mu abantu abafaananako bwe mutyo mbadde njagala nnyo oyo omwami kambuuze ekibuuzo kino waba wansi nga wali awulira nawe Malemadi era ngenda kikubuuzo ekinziremu tuleme kuba bawumba tutuna bawutta ombaka wa palamenti talina munnayuganda yenna gwe yaganye kukola kyayina kukola olyosi n'ogenda nga bwemyotinga omubaka wa palamenti talina munnayuganda yenna gwe yaganye kukola kyayina kukola abaka ba palamenti bemugaana okujaganya era tebanawe bajaganyiza olwe badde balina okwebaza abantu ababawadde akalu kuba ne be balondedde abaka ba palamenti Kyagulanyi Ssentamu yawanguddewo kyabadde kibi kyabaka ba palamenti okwebaza abalonzi n'otunuulira emitwe gy'abamu abawumba tutumu aboogera abamu n'okulonda temwalonzi
Seremba nze nkugambye
aboogera abalinga gwe n'okulonda tebalonzi
andi mwe bwe buzibu bwammwe muva ku nsonga enkulu ne muda ku nsonga obutono nze sebo nondera kabowa okitegeera era kyawalonzawo obululu 3 mwami Museveni afuna obululu 45 oba okitegeera kabowa
kati Kyagulanyi baba yafunawo obululu atwalaawo yawangudde awo yenna Ssolo si bwe kiri
webale nnyo
si bwe kiri kibi ky'okwebaza bannayuganda okubawa obululu kibi ki wangi abali omumbule kibi ng'omuntu yawangudde okwebaza bannayuganda okumuwa obululu wangi nyabo
mwasibye kyamunnaye
yetuli mu mejjo g'amooza bani ayina eŋŋombe
abantu abamu nze munnaye bansobedde wano ku apu eno simanyi buzibu bwa bannayuganda bwe tulina abantu oba babadde baagala ekibiina kya Nuupu kireme kufuna muntu n'omu mu palamenti sikitegeera abantu bali kubayiminga MPs ffe nga bannayuganda tewali kye tutaddewo okulaga nti no tulina kye tutaddewo leero SG waffe kye yababuuzizza gwobuuza tuddako kigukozizzaako ki oli mu kunenya omubaka tugezeewo Junior Nassolo naye alimu omuntu omu nga gwe bw'oli muntu omu ekyokuba nti mubaka wa palamenti tekimufuula nti no wanjawulo ku ggwe okitegeera naawe osobola okuba ng'olina abantu abakukkirizamu n'okusinga Nassolo olina abantu
Your Honor, I've tried to highlight the relevant parts because going through all of them, it will take time. But particularly, Your Honor, you look at page number 14 of the you look at number 14, number 15. When this honorable court is handling an application of this nature, acts as an appellate court, it is reviewing the decision taken by the returning officer, process of tallying and declaring results. It's reviewing the process of tallying and declaring of results. In section 73 of a mandatory count, is to ensure where an election that the winning candidate has had verifiable results from the ballot boxes to represent the will of the electorate. That's why this court has a duty, if it permits a recount to be conducted, to verify each and every ballot in the box. So, Your Honor, had the returning officer executed his duties as required by section 73, we would not be before you. So it is therefore necessary, Your Honor, that the will of the people of Kalungu West constituency is fully confirmed and verified from the ballot box, from the ballot papers in those ballot boxes. Because the framers of the law had in mind that there could be numerical, arithmetical, or other errors made during the counting of votes at the polling station, at the respective polling stations. And Your Honor, it would appear clearly that a recount where the vote margin is below 50 is mandatorily supposed to be conducted, which was not done in the matter before you. The other reason, Your Honor, the applicant deposes under paragraphs number 12, under paragraph number 11, 12, 13, 14, and 15 of his affidavit in support that he received the information during tallying from his agents across the constituency that the results that were being announced progressively by the returning officer were contrary to what had obtained at the polling stations. And he mentioned in the list a number of polling stations under paragraph number 12. Your Honor, the applicant alludes to the information from his polling agents that there were serious errors and manipulations during the vote counting. Your Honor, this application, therefore, serves a fundamental purpose of ascertaining and filtering the actual valid votes for each of the candidates in those different ballot boxes. Your Honor, that's the fundamental purpose of this application. And Your Honor, this exercise is so important that it serves both the parties and the courts from crossing into another longer process of petitions after gazetting. Your Honor, there is a fundamental argument by the applicant that at the tally center the applicant was not given a tally sheet. He was not given a tally sheet by the returning officer. He was not given a tally sheet by the returning officer, and therefore he was not in the position to ascertain whether what was tallied was corresponding with the results in the DLR forms at the different polling stations. And Your Honor, that is under paragraph 14 of the affidavit in support.
Therefore, you want?
Therefore, Your Honor, he was unable to verify that. And Your Honor, you will note that all the respondents, none of them had attached any tally sheet. It is a requirement, Your Honor, that even as when, if this court allows this application, that the tally sheet would be the primary source, would be the secondary source, deriving information from the primary source, being the DLR forms, of the results being tallied and returned to the parties. So, Your Honor, all this complex can only be untangled by this honorable court ordering fair count. Your Honor, the applicant has deposed, and his arguments have not been disputed, that to his knowledge, after polling, the ballot boxes are in the hands. The ballot boxes are in the hands of the first and second respondents at Kalungu. That they were also locked in a secure store, and the applicant, Your Honor, took a photo or a record of the serial number of the seal on that store. Your Honor, you have no contrary evidence. That is under paragraph 19. Your Honor, you have no contrary evidence from particularly the first and second respondents, as to the change of the state of these ballot boxes. Paragraph 19, Your Honor. And in any case, Your Honor, Section 74 requires the first and second respondents to ensure that all electoral materials are securely kept.
Section what?
Section 74 of the Parliamentary Elections Act.
Yes.
Yes, mandates require the first and second respondents to ensure that there is proper and safe custody of the ballot boxes and all electoral materials once a party expresses intention of seeking court's intervention with the vote recount. So, Your Honor, we submit that this is the proper case where this Honorable Court should invoke its powers and the order for a recount. Your Honor, we are also guided by the case of Byanyima Winnie and Ngoma Ngime. That is revision application revision civil revision number 9 of 2001. Court would be in position to conduct a recount if the integrity of the materials appears to be okay. Prima facie, as we submit to you now, there is no contrary evidence that these materials are not securely kept. Your Honor, that's my submission as to the application. Your Honor, now the last segment, and I want to make it very brief. A recount, if ordered by a court, is under the direction and supervision of court. It's a court recount. From the proceedings before this court earlier on, Your Honor, court intimated its earlier ruling that should it find met in the application, the recount can be conducted from the ground at Kalungu, at the nearest court in Kalungu. Your Honor, it is our prayer that court maintain that position in allowing this application, that the recount be conducted at Kalungu. And Your Honor, as an officer of court, I'm also making suggestions for consideration by court in making its directions if it agrees with us. One, that at the time, Your Honor, of retrieving the ballot boxes from the tally center, the parties or their agents are in a position to confirm that the store is sealed as locked as it was with a seal. And then open in the presence of the parties that all the ballot boxes, Your Honor, for this constituents, before being loaded on any transit truck, they are first assembled and verified to have their seals with photos taken.
Ballot boxes are what?
Are still intact with their seals. Photos to be taken at the first respondent, as the first and second respondent's office store where they are kept. For that record first to be taken out, that the boxes are still securely intact. That, Your Honor, those boxes be loaded and transported to court in the most secure environment, and Your Honor would suggest it should be a body box vehicle Box body. Call it box body. Which can sexually be sealed. That there should be no occupant behind when it is being loaded. Your Honor, this can be the ordinary box body, or even the Electoral Commission can afford, or even a bullion van, because these are valuable materials.
Who foots the cost with your submission?
Your Honor, we can foot the cost because we are interested in justice. We don't want to a scenario of what has happened in many of other cases. That Your Honor, after loading this truck, the vehicle is sealed.
Just a minute, Counsel. You'll get that time. Your Honor, I've never seen any submission where a lawyer is telling court how to give its direction. Wait, this is a court. If court is to allow for the exercise, it will be the directions of court, and we cannot, because you cannot start saying it must be a billion van, it must not. I think we leave that to court. Let's just convince court that there is sufficient cause or not. Or not. And then that stage, by the way, just letter of record. Mr. Tebias has gone through these things with me. We have gone through them. It is not done that way, because at every stage, assuming court says there must be a recount, even the process of recount is actually a court process, because we sit, we appear as court, so we cannot tell court now want you to do this. I think we leave that to court. Yes.
Your Honor, my friend has did not probably attentively listen to me. As an officer of court, I am under duty to give the opinion, to the suggestion to court, for court to consider when it's making its directions. And that's what I did. I'm not directing court, Your Honor. I'm asking court to consider when it's giving directions. And Your Honor, I draw this from experience. Your Honor, in one of the cases, Your Honor, in one of the cases that I cited in Ngomangime, there was a recount between Idi Rubia Chisiki and I think it was coming to this court. Your Honor, by the time boxes reached this court, they were in tatters. Your Honor,
I think we are good scholars of history. We should not be subjected to that. In addition to that, the submission of my land senior creates a test as to whether this court is competent to oversee this exercise. I think that whole exercise should be cut out of the I submit.
Try, your time is...
Most obliged, Your Honor, let me wind up in 5-3. Most obliged. Your Honor, I was making that submission in the belief that court may order the transportation. But also at the same time, Your Honor, I want to bring to the attention of this court the provisions of Section 7 of the Magistrate Courts Act. Specific. Section 7 of the Magistrate Courts Act. And subsection 2, Your Honor. The court can sit at any place. And where a court is seated would be considered as court. Court can as well order that the count is done where the ballot boxes are. Your Honor, specifically to avoid the possibility of interfering with the integrity of these boxes. We are talking about politics, Your Honor.
This is my land senior here has submitted that these ballots are in secure places in a store, and has even made a prayer that they will verify that the seals are still valid and everything is intact. I think we should not dwell and waste so much time on that. I submit.
Please, madam.
So, Your Honor, I don't know why my friends are uncomfortable with the court coming with specific clear guidelines on this. And Your Honor, the applicant has deposed that he received information of the possibility of interfering with these boxes in their transit to court. So that's why we want to hedge against all of this. Your Honor, it would be in futility if this court gave an order and it is not executable because something has happened. I'm making all this submission to ensure that once court gives an order, it is executable up to the end.
The greatest point you have made is that the ballot boxes are in secure
That's true. So, Your Honor, I was talking about the scenario. I don't know why my friend was uncomfortable with it, but court also can consider it. Section 7, subsection 2 of the Magistrates Courts Act. Yes. So, Your Honor, all that said, we wind up by inviting this honorable court to find that the clear and compelling reasons for this honorable court to conduct a recount. We humbly pray so, Your Honor. Thank you.
For the record, Kale Balaka, we oppose this application and submit that it does not meet the conditions for grant of an order of recount. And we have two dimensions. The first dimension is that the applicant has heavily dwelt from paragraph 4 to paragraph 9 of his affidavit in reply. Actually 10, 17, and 18. Paragraph 3, 4, 5, 6, 7, 8, 9, 10, 17, and 18 of his affidavit on the failure of the returning officer to conduct a mandatory recount. And he has also, with respect, misrepresented the ruling of Justice Chibuka Musoke in Kasivante Moses versus Katongole Singh. That's election petition number 23 of 2011. My Lord, that ruling did not say that if you fail the mandatory recount, you appeal to the Chief Magistrates Court. When he stated that Kasivante said that this is what the judge said in Kasivante, and this is what he was relying on, it appears to court that the jurisdiction which section 55(1), which is the current section 74 of the Parliamentary Election Act confers upon a Chief Magistrates Court is very peculiar indeed. It is very unusual. It is, as it were, essentially an appeal against the returning officer's tallied and announced results. Tallied and announced results. It's not when he has failed to conduct a mandatory recount under section 73. That is the distinction. So the submissions in respect to all these paragraphs are overtaken by events, because the returning officer clearly indicated in a paragraph in Annexure C that when they requested for mandatory recount, in paragraphs in Annexure C, which is attached on the application, on the affidavit of the applicant, he said that this is in response to a request for mandatory recount of election results for Kalungu West constituency. I wish to inform you that after declaration of a winner, the returning officer has no legal mandate to do a recount. That is the correct position of the law. So, and an applicant who has lost that opportunity has another opportunity under section 74. That is the one before you. So the two are not symbiotically or mutually together. They are distinct and different. So it's not true. The appeal we are talking about is the appeal against the declaration and the tallying of the results. And that is under 74. So it's a mixture. He has mixed 73 and 74. So you must disregard that limb of his submission. 2, I do agree with the counsel for the applicant that Kasibante. This is what the judge said, Your Worship. First, the court hears the application for the recount. The applicant must justify making it by satisfying the chief magistrate with the good reasons why the court should order a recount. Did the applicant use any evidence to satisfy you why a recount must be made? We are saying no. Why do we say so? The answer is found in the third respondent's affidavit in reply, which is on this record, which is on the record of the court. There are 2 reasons. First and foremost, the applicant has not shown to this court the poll results he obtained, which was allegedly different from the actual votes counted and tallied. He has not shown to this court. The applicant is talking about absence of DRA forms. Actually, DRA forms are a creature of the law. DRA forms are a creature of the law. Under Section 69 of the Parliamentary Elections Act, every presiding officer shall fill the necessary number of copies of the prescribed form for the declaration of results as follows. D. 1 copy shall be delivered to each of the agents of candidates, or in the absence of those agents, to any voters present claiming to represent the candidates. There are no DRA forms which the applicant has attached to make this court satisfy that probably this was where the problem was. It is a requirement of the law. The law presumes him. Now, when he comes before you without any DRA forms and wants to cast the burden on us, we do not hold that burden, because the burden of proof is on the applicant. That is the law. So, how will you know? How will you know, court, that the results which the applicant obtained were actually different, which is going to make you to have a recount? You need to go to the primary source, as rightly submitted by Counsel Ambrose Tibias. He said the primary documents are the tally sheet and the DRA form. Those are the primary documents. Even before you go for a recount, those are the primary documents you look at. Tally sheet and DRA form first, and tally sheet. He has come to court without any of those documents. And the burden can't be on us, because it's him who wants to satisfy court. 2, the applicant's whole application is based on hearsay, falsehoods, speculation, I wanted to add another word, assumption, and wild allegations without foundation and the basis. I don't want to add any extra time, because TVS I will complain. So why do I say it's tainted by hearsay, falsehood, speculation, assumption, and wild allegations? He starts it, paragraph 11. He says, this is the applicant, that while at the district tallying center, I was reliably informed by my agents That's paragraph.
After paragraph 11 of who?
Affidavit of the applicant in support of the application. Paragraph 11 of the affidavit in support of the applicant support of that.
Yes.
He says, now this is why he wants to satisfy you. He wants to satisfy court. He says that while at the district tallying center, I was reliably informed by my agents that the results announced at the different polling stations were different from the results being tallied and declared by the first respondent to give a winning margin to the third respondent. First of all, these agents are faceless. He has not mentioned who these agents are by name. He has not mentioned the polling stations where these agents saw that information and informing him. As if that's not enough, in paragraph 12, he again said that according to information from my agents, the agents remain faceless, has not mentioned them. This application came after results were declared. At least you should have known his agents. He has not mentioned them. Here, he mentions polling stations. Paragraph 13. He says that I know for a fact from the different polling stations that I scored highly. How did he know? Was he in all those polling stations? He again has not mentioned the name of the agents who told him that. He has not mentioned the polling stations. And he has not mentioned, he said he scored highly. What was it? He has not even mentioned. What was that highly score? Again, in paragraph 14, he said he requested for a tally sheet from the first respondent shortly after the declaration of results for purposes of comparison between what the first respondent was entering with what I had from the different DRA forms from my agents. He has not even attached the different DRA forms he's talking about or who these agents are. And then, in paragraph 15, he makes a sweeping statement, said, I do not know what was recorded in the first and second respondent systems and declaration of result forms. But under 66, he's supposed to have that. He has an agent. So if he does not know what was scored, does he want to use this as a fishing expedition? No. Courts are not fishing expedition, used for fishing expedition. Paragraph 16, he says, I have also reliable information from my polling agents at the different polling stations that most of the invalidated ballots belong to me. 1, these agents have not been mentioned. 2, the polling stations have not been indicated. Even the votes, the number of votes which belong to him, which were invalidated, how many are they, he has not mentioned. What did the court say about the position of using these faceless agents? Such a similar matter arose in the case of, I'm going to supply it to court, in the case of Dr. Baiga Michael Philip Lulume versus Mutebi David Ronnie and the Electoral Commission. It's election petition number 014 of 2016. It was before Justice Batema. My Lord, in chapter on page 3, there was a preliminary issue raised by Justice Sekana when he was counsel that the affidavits filed by the petitioner were based on hearsay. And this is what the court said in page 3. It was alleged that the petitioner sets out allegations relying on information he got from his agents and not within his knowledge and belief. The various agents are not specifically named as to state which particular information they gave him, that this is hearsay. This is what the judge said. I would agree, and more so, if the information came after the filing of this petition. Paragraph 5, 12, 14, 22 to 25 and 30 of the affidavit shown by the petitioner allegedly hearsay. The alleged information has no specific direct source named in the body of the affidavit, and one wonders how the petitioner will verily believe such information to be true and correct. I will place very little, if not at all, any evidential value on hearsay. Of course, the law makes some exceptions. In Isubuga John vs. Electoral Commission, the court rejected parts of the petitioner's affidavit in support of the petition, where the so-called agents, if any, remained voiceless and faceless. Similarly, in the instant case, the so-called agents and supporters are voiceless and faceless. That is on page 3 of the ruling. This, where the agents remain voiceless and faceless, it is hearsay. You cannot rely on them, and they cannot give you information to satisfy you, your honor. Of course, he has also been gracious to us, Mr. Ambrose Tibiasa, Senior Counsel, when he cited Order 19, Rule 3 of the CPR. That order squarely accesses, it cuts all those parts of his affidavit because they are based on hearsay. This court should not be taken for granted. You come to this court with tangent evidence, which is cogent, and then court will be satisfied. But he has relied on hearsay, and under that rules, affidavits must be affidavits to facts as the deponent is able of his or her knowledge to prove. It should be restricted. But now here, the entire, if I've removed the paragraphs which are complaining about the aborted recount, and if I've removed the paragraphs which are dealing with hearsay, the whole affidavit in support collapses. There's nothing before you, and there's no reason. And it's not by emotions. Courts act on cogent evidence. There must be, court must be satisfied. The minimum is if the applicant, your worship, brought the DERA forms. The minimum is if they brought tally sheet. The minimum is if he came up and he said, by the way, this is what I got, so that when we go to the boxes, then you'll be guided. But from the outset, he is praying for an order for court for the count of all the ballot boxes for the position of the direct elected member of Parliament for Kalungu County Constitution be issued. He is in a fishing expedition. You can't have a grievance with it. All elections are tight. You just win an election, it's 50 plus 1 vote. But this is not plus 1, it's 49. That's a big one. So, the other advisory opinion, I pray you disregard, because this court has the jurisdiction, and it is this court which can give directions if it is satisfied. I am submitting that this court has not been certified. The issues of the recount, how it aborted, was a segment of the election. In the case of Ngomangime versus Winnie Byanyima, which I had the privilege to argue before Justice Chibuka Musoke, it was clearly indicated that elections flows like a river. Once this segment has passed, you don't go.
yalangiriddwa nga yawangudde obuwanguzi bwe etteeka limukwata talina watandikira kugugunga abantu gw'omulowooza ababaka abo basiru mulowooza tebaagala Kyagulanyi atule mu ntebe mulowooza lwaki temunnabalabako ku kkubo Zaake lwaki temunnamulabako ku kkubo waliwo asinga Zaake Fujjo mulowooza lwaki taliiko ku kkubo bamanyi amateeka bo bennyininyini be bagabaga okitegeera kati saawa zino etteeka limukwata kati gwe Munnayuganda alinze omubaka for sure tomanyi ki kyolwanirira just go back your home webake okitegeera olina emyaka 5 gigweko ddeyo osimbe layini ku lw'ensonga gwe tomanyi ki kyokola ki tomanyi ki kyolwanirira teri muntu kiringa wonagamba nti nno banaye Bannayuganda ekituufu kiri nti tulina endowooza nti gundi alina okutandikawo kino waliwo benawulya nga bagamba president tannalagira president tannaduumira naye ng'omusajja yaduumira tetulina nakye tumubanja this time already ogugwagukoze so enva waggulu nga mbagamba Bannayuganda nti mwebereremu enkya kulonda tuge tulonde bammeeya kituufu tulonde n'abaddako kyemulina omumanya we muba muvuddeyo nga muzze kulwanirira ggwanga lyammwe nga mulowooza nti obuwanguzi mugenda bufunamu nnaku 3 nnaku 4 mulina omuzannyo tetugenda bufunamu ezo ennaku ze musuubira luno olutalo lusobola n'otwala omwezi nze nkibagambye nga nze mukitegeere oba ovuddeyo nga gw'olina ebbugumu lyo lya nnaku 3 nnaku 4 nze mbaliriza
kale sebo mbadde nina kyenjagala okubuuzaamu kyoyogeddeko awo ku kyababaka
Esebo
ogenze n'ogamba kyababaka singa bagugunga abantu etteeka liba libakwata nga libakwatira mu Uganda empya gye baba bagugunza abantu ne bajja ne bagirwanira ne bagigendamu Kyagulanyi yaba agenda obasiba oba tuba tugenda bugenzi era twegugunge tudde buzinga nakyemalira yalemedde ku buyinza mbadde mali twegugunga tukyuse eggwanga lyaffe tugenda mu Uganda empya katati libakwatirawa nga tuli mu mpya
mabega waffe nze kati wenkwa ekyokulabirako mu kitundu gyendi eno waliwo emmotoka egende wamba abantu